spouse or your children, your parents, siblings, depending on who's alive and who's the closest relative to take. Trust, there are lots of different types of trusts. I do a lot of special needs trusts for my clients. Those are trusts for a disabled beneficiary who is enrolled in public benefits, such as Medicaid and SSI. Lots of things to consider: taxes, whether you're going to lose the step-up in basis for any grantor of a trust. It's the person who establishes the trust. Who are the beneficiaries of that trust? What kind of benefits are they on? A lot of times we'll do a trust in order to kind of shelter assets for an elderly person to enroll in Medicaid, but you have to be very, you have to consider all of the rules for Medicaid, which we'll talk about later, with regards to transferring assets. So there's a lot of things to consider. Trusts are not for everybody, but a lot of people that I create trusts for normally think, oh, I don't have enough money, I don't need a trust. And I'm like, I'm from a small town in Georgia, and trusts are, I always thought that they were these fancy things, but they're really not. You can put $5,000 in a trust if you need to. So it's not a matter of having a lot of money. It just depends on what the person's situation is. So these two documents, a financial power of attorney and a medical directive, are extremely important. I cannot tell you how many of these I write a week for clients, but I do them in order to help people, seniors and young people. If they need help later, their family or whoever they name as their agent will be able to help them without having to petition for guardianship and that sort of thing normally. In Virginia, there are two documents. There's a financial power of attorney. It's also called a general durable power of attorney. The medical directive is often referred to as a healthcare power of attorney, but in Virginia, under the statute, is officially deemed an advanced medical directive. That also encompasses language in a living will, which a living will says, yes, I do want to be kept alive on a feeding tube, or no, I don't. All of that is included in the medical directive. So the financial power of attorney is where it's a 2 or 3 page document where you appoint another person to act on your behalf when it comes to financial matters, be it bank accounts, real estate, taking out debt in your name. They can do anything that you could do. So they're extremely powerful documents. You only appoint an agent who you trust wholeheartedly, not who you kind of trust or you think will do the right thing. You have to trust this person, mainly because it goes into effect immediately when you sign it. It doesn't go into effect upon incapacity or incompetency. It's effective when you sign it. And so you have to trust the person you give it to. There used to be a power of attorney, and you can still do them. I don't do them that often, but they're called springing. They spring into effect upon incapacity. Those are much harder for the agent to actually use when they need to use it. So 99% of powers of attorney are durable general powers of attorney. They go into effect upon signing. We can include this language in the power of attorney depending on the family situation. This gifting language is very important for my clients because a lot of times I have a client who needs nursing home care and needs to be on Medicaid but may have too many assets. So a power of attorney could maybe move those assets around so that I can enroll that person in Medicaid. Well, the power of attorney doesn't have the authority to do that unless the power of attorney expressly says unlimited gifting. Otherwise, if it doesn't, they're limited to only transferring $14,000 a year of that person's money under the Virginia and federal law. So that language is important, but I don't put it in every one because it just depends on the family situation and how what our goals are. There are other powers you can give to the agent. The last one, delegate authority to another, is very important. Yesterday I was seeing a lady in Mechanicsville, and her husband designated her as his power of attorney, did not name a backup. So normally I try to always name a backup if at all possible. So Miss Ruth is no longer able to help him because she is in poor health and he is in poor health. And she does not have the authority in the power of attorney document to appoint someone to act in her place. And we can do that. We can write that in the power of attorney, which we include. That way, if the attorney had written that in there, she could appoint her daughter or his daughter to help at this time, since she's not able to. But now we're going to have to either redo the power of attorney if he's able to sign it, or petition for guardianship, depending on how he's doing. Here are different things that the agent or power of attorney can do. You can make a power of attorney more narrow, and it's called a specific or limited power of attorney. If you just want someone to help with a real estate closing or certain bank accounts. I don't do many of those, but in certain instances I have. So the other document is an advanced medical directive. The person who is giving the authority to another person, to an agent, is called a principal. Again, I try to name a backup if at all possible. This document allows another person to help with your health care matters, admit you to a facility, consent to treatment, decline treatment, but it's only effective that the person you name can only do that if you are unable to make an informed decision as deemed by a physician. So if I'm at the doctor's office and my husband is my agent under a health care directive, he cannot consent to anything on my behalf if I'm able to communicate what I want to the doctor. Again, it's also known as a healthcare power of attorney in Virginia. Same with the power of attorney, the photocopy is just as good as an original. You don't have to have the original with you everywhere you go. The photocopy is just as good. Banks may want to see the original, but they cannot require that. Okay, so here are things the agent may do. And it's extremely important to have these documents in place no matter what your age. I do elder law, but I prepare these documents for people of all ages because I don't know if I'm going to be in a car accident tomorrow, and I don't want my family to be in a bind if they can't access my accounts, if they can't talk to my doctors, and so forth. So these two documents are not limited and not just for seniors at all. And the same with the will. But I have clients that come to me and say, oh, I got to do my will. It's so important I do my will. And I'm like, yes, it is, but you also needed these two documents because I have so many clients who didn't have these documents in place, and it's so hard on the family to then gain control and get any power. A lot of times we have to go to court and have the judge give them authority to access financial accounts and medical information. And it's just unnecessary if people would just sign these documents in advance. So whenever you choose an agent for either of these documents, always choose someone that's trustworthy, that's going to be loyal to you, that knows your wishes with regards especially to health care, whether you would want a certain treatment or not. And remember that the person can act at any given time, and especially if you become incapacitated, they can act, so you need to trust them. If you get divorced, it revokes the power of attorney. I don't believe it revokes the medical directive, but I don't know many exes that would try and use it, but it can happen. You can always revoke it. They're not permanent documents. You can physically destroy it. You can create a new one that revokes it. You have to notify the agent that you're revoking it, especially for the medical directive. So if you don't do these documents, or if the documents you have are not sufficient to meet the needs of the person, then the family may have to petition for guardianship. So in Virginia, we separate it out because we're old-fashioned. A lot of states say, when I was in Pittsburgh, guardianship is everything. Your guardianship of the person, your guardian of the estate. Virginia is different. So guardianship is just of the person, their health, their housing, their welfare. So if you're guardian of a person, you're in charge of their health care decisions, where they live, what doctor they go to and all of that. You have no control over assets. So a conservator is the conservator of the estate in Virginia. So a lot of times when people petition for guardianship, they also petition for conservatorship in the same proceeding. And then the conservator has control of the assets. It is expensive. It takes at least a month, depending on which court you're trying to get in, to get before a judge. And so if you're trying to help a person who may need to be moved into a facility and you can't get to their medical records or to their finances, this can really delay the process and delay your ability to help them. But it can, once you're appointed, you have full control. The court declares that individual incapacitated, and whoever is appointed as guardian and or conservator has full control over that person. I do not like to go before, it's hard for me to go before a judge and ask the judge to declare a person incompetent or incapacitated. I have to do it, but you're completely stripping a person of their right to make any decisions for themselves. And I don't think that's what anybody wants for themselves when they get older. And if you do a power of attorney, and if you sign a medical directive, you can help your family avoid having to do this. Okay, so that's estate planning and disability planning in a nutshell. Elder law, when I told my mom that I was going to be an elder law attorney, she was like, what is that? So a lot of people don't know or have never heard of elder law or don't really know what it means to be an elder law attorney. Here are some of the areas that I work in on a day-to-day basis. A lot of times I'm working with the adult children of my clients. The senior may have dementia or MS or something, or they're not able to really meet with me and make decisions in their best interest. So a lot of times I'm meeting with the adult children to help the parent, to help figure out should we move mom, what's the best place for mom, and who's going to pay for her care in a nursing home and that sort of thing. Most people, if they've never had to deal with an elderly person, they have no idea where to even begin. They're just thrown into this very chaotic situation and don't know what benefits are out there. A lot of times children are in the dark as to what their parents' assets are, what insurance they have. They're like, oh, mom's on Medicare. Well, there's a lot more to it than that. So it's good for families, especially as parents get older, to communicate those sorts of things, or either have that information in one place so that the child can easily access it. So long-term care planning is a lot of what I do, and what I mean by that is what happens when the aging process kicks in and a person either has physical impairment or cognitive impairment, and they're not able to manage all of their affairs like they did before, be it by health care or financial matters. A lot of times people can remain in their home and age in place. That's what most people want to do. But sometimes people can't do that. They need to go into a facility in order to be cared for. So there are different housing options for people who are in various stages of aging and need additional care. They can move into an assisted living facility, which range in cost, but they start at about $3,000 a month for a person. Some assisted living facilities, more and more, are having secured memory care units, so that's really helpful for a lot of my clients. Skilled nursing facilities, that's a nursing home, and then a lot of times people can, or if they're still able to live on their own independently, they can live in an independent living facility or stay at home or in an apartment and maybe have aides come in to help here and there. So who's going to pay for long-term care? Well, you can pay out of pocket, and that will, and some people have more savings than others. A lot of my clients, may have $100,000, may have $500,000. It just depends. May have nothing. So, you can pay out of pocket. Medicare will pay for some of the long-term care housing options, but not many. And the same with veterans benefits and Medicaid. We're going to talk about each of these next. And then long-term care insurance. Most people do not have long-term care insurance. If you're going to get it, you should do it when you're younger, at least 50 years old, to really get a good rate and a good policy. But a lot of people don't think about it when they're 50 years old. They think about it when they're 65, and it might be too late or it's too expensive, because they have all these underwriting requirements, and anything wrong with you, they may not be eligible for a policy. So veterans benefits, there are two types of veterans benefits. There is disability compensation, which is people that incurred a service-connected disability when they were serving in active duty. And that's income they get every month. This VA pension aid and attendance, which you may have heard that term before, it is for people who need help with activities of daily living, such as bathing, dressing, that sort of thing, or have a cognitive impairment. It doesn't require you to have any service-connected disability. It's available for veterans, their spouses, or their surviving spouses. It's means tested, so I had the lady I went and saw yesterday, her husband's a veteran, and she was like, well, can I get him on aid and attendance to help pay for the assisted living facility? And he met the military service requirements, but they didn't meet the means test because they have too many assets. So it's very complicated, and VA does not issue specific guidelines about how many assets a person can have. There are certain rules that lawyers that practice in this area, we kind of say, well, if a person has 40 or 50,000, they might be eligible if they're married. If they have 80, they may be eligible. But if they're above 80 or 100,000, they're likely not, as far as assets, and that includes a home, they're likely not going to be eligible. So a lot of people are not eligible for that reason. Medicare, a lot of people think that Medicare will pay for nursing home care. Medicare does not pay for the majority of nursing home care. Medicaid does, but Medicare does not. Two very different programs, which we're going to talk about briefly. And a lot of my clients don't know the difference. They might be on Medicare, but they don't know what's Medicaid. They don't have any idea what the difference is. So Medicare is a benefit program for people who are 65 or older, or who are younger than 65 but have been declared disabled by Social Security, or people that have end-stage renal disease, which is kidney disease. Medicare will only cover skilled nursing facility care if a person has had a 3-day inpatient hospital stay preceding that, and they need to go to the nursing home for rehabilitative care or skilled care, which is medically necessary care, such as wound care or physical therapy or something like after a hip. If you break your hip and then have to go have surgery, a lot of times people will recover in a nursing facility, and Medicare will cover that for so many days. Medicare will not cover custodial or non-skilled care, which is what most dementia patients need. So Medicare will not chip in a bit for that. Medicaid is what covers the custodial care. It is means tested. There is a 2,000-page Medicaid manual in Virginia, which sets forth all the eligibility requirements, and we're going to talk about that just a little bit later. But if you're a single individual, you pretty much have to have nothing to get on Medicaid. If you're married, you can keep a little bit more. Medicaid, a lot of people don't know this, so this is just something to just keep in mind. Medicaid will pay for nursing home care if the person is eligible, but it will also pay for in-home care, and that's called Medicaid waiver. It's community-based care. There are different types of waivers. There is a waiver for an elderly person who has dementia. There is, or just needs, maybe they don't have dementia, but they just need help in the home to look, with bathing and so forth. There are also waivers for people who may have been born with an intellectual disability. So a lot of times people are on those waivers if they may be autistic or something and can go to a day program or have aides come in the home from an early age. So community-based care, those waivers are not limited to seniors. So if there's a disabled person, they also may be eligible for this. But a lot of times people don't realize that Medicaid will pay for aides to come in the home. They're not nurses, they're just personal care aides, and they'll come in the home for 6 to 8 hours a day and help look after an individual. And it can help keep a person out of a nursing home. That's what the goal is. If we're trying to keep a person at home for as long as possible, and they have a spouse that can look after them but they need help a few hours a day, a lot of times I'll enroll them in Medicaid waiver. All right, so with Medicare, this is who's eligible. Medicare has 4 parts. Part A covers your hospital care. There's a premium of $104.90, so $105 a month that's automatically deducted from your Social Security benefit for Part A. Part B, there is no premium, but that pays for outpatient care, doctors, x-rays, and that sort of thing. Both of these have deductibles, co-pays, and so a lot of times people will say, well, I'm on Medicare, so Medicare, I shouldn't get any bills. I don't know, for whatever reason, people just think they shouldn't have co-pays when they're on Medicare, or they don't expect to, but you do. So people will get another insurance plan to help pick up those out-of-pocket costs. Part C is Medicare Advantage plans, which is just that. These are plans you enroll in addition to Medicare. You can enroll in these plans every year during open enrollment. That's from October to December. And the new plan, your plan will go into effect in January. Those plans will help cover some of the co-pays associated with that you'll have if you're enrolled in Medicare. So if you have a co-pay for going to the hospital or a doctor, your Advantage plan may pick up some of that cost. Part D is prescription drug insurance, so that's a separate plan as well. I have clients who are usually on 2 plans in addition to Medicare. They're in their Medicare Advantage plan, and they're in if you're in a Medicare Advantage plan, that has your Part D rolled in. But that's a separate plan to help, because prescription drugs are very expensive for a lot of my clients. They think, going to the doctor and all of that, that's nothing. But when it comes to what their co-pays are for drugs, you need to make sure you're in the right prescription drug plan so that you reduce your co-pays as much as possible. A Medicare supplement is another insurance plan that will reduce your out-of-pocket costs. They're more expensive than the Medicare Advantage plans, and they do not include prescription drug insurance. So if you're in a Medicare supplement or a Medigap, you will also need a Part D plan. It's all kind of complicated, but Medicare.gov is very useful. And there's a local Senior Connections offers Medicare counseling to people who don't know what plans to enroll in, and it's up on Cary Street. So people a lot of times will just enroll in a plan and stay in it for years and years, and it may not be the best plan for them because their prescriptions change, their health declines, and so every year people need to reassess what plans are in during the open enrollment period. Okay, so Medicaid, there are a few different types of Medicaid programs. The main 2 types I work in are these 2, the age, blind, and disabled, which is ABD Medicaid, and then long-term care Medicaid. So if you see a person who's walking on the street, or if you've probably heard about people who are just poor but they're on Medicaid, that's the first one. They likely, if they're younger, have been declared disabled by Social Security because that's required if you're under 65 to be enrolled in that, or they're blind. Single mothers and children, they're in a whole different type of Medicaid program with completely different rules than these 2 types of Medicaid. So, so it depends, the eligibility requirements depend on what type of Medicaid you're trying to enroll in. Long-term care Medicaid is what provides for nursing home care and the Medicaid waiver, the community-based care that we talked about earlier. And that's what most of my clients, I try to enroll within that. So, so there's 2 eligibility criteria. There's financial and medical. The medical is you have to need help with 2 or more ADLs to be eligible for the in-home care or the nursing home care. And you have to either be aged, which is 65 or older, or you have to be under 65 and have been declared disabled by Social Security, or be blind. And they have a definition of what blind is, what the vision, all of that has to be. The income limits, so if you're going into a nursing home, your income cannot exceed the private pay rate of the nursing home, which for the large majority of my clients, that is not a problem because private pay is around $7,000 or $8,000 a month. And most of my clients, not total household income, but the person that's needing to move into a nursing home, their income does not exceed $7,000 or $8,000. So this does not usually prohibit my clients from attaining nursing home care or eligibility. If you're on community-based care, if you're looking to enroll in that, your income cannot be more than $2,163. If it is, if you can get on Medicaid after you incur a lot of medical costs, it's the spin down kind of procedure. But if your income is over around $1,200, but under $2,163, you may owe that difference. You may have to contribute that toward your own care, depending on if you have a spouse. They may be able to keep that income. But if it's more than $1,200 and under the $2,163, and it's a single person, they're going to have to pay for the aides first with that money before Medicaid will chip in. Resource limits. So for a widow or widower who needs nursing home care or Medicaid waiver, their accountable resources cannot be more than $2,000. So that does not include your residence if you live there, or if you have if you have a minor or dependent or disabled child living there. But a lot of times I have a widow who stayed at home and then needs to move into a nursing home, and the house is exempt for the first 6 months, but then after that we have to make an effort to sell it, which is what a lot of people, that may be all they have, they want to leave that to their children, so we have to kind of be creative and try and preserve it as much as possible. That's why it's good to be proactive and plan for what happens if I need nursing home care later. It makes things so much easier, and you can preserve a lot more of your wealth that way. For married couples, the single person, their asset, the person who needs nursing home care or Medicaid waiver, community-based care, their assets cannot exceed $2,000, but the community spouse is allowed to keep the first $24,000 and then up to around $115,000, $116,000, $117,000. It went up this year, so $117,000. We do a lot of calculations to try and maximize what is allocated to the community spouse. But I had a client earlier this year who had maybe $300 in assets, so it was about $250. So we were able to preserve half of it for her, but then the other half was allocated to her husband, who was at the VA nursing home, and she was having to pay $6,000 and $7,000 a month for him. And we were able to preserve a lot of that during using various strategies. But if she had not seen elder law attorney, she would have just had to spend all of that money for his care. The problem is, she's in pretty good health, and she's going to need as much, those resources to live on. So that's why Medicaid lets the community spouse retain a good bit, but not enough, but a good bit. So Medicaid exempts some of the resources, the principal residence up to a certain value. One car, no matter if it's a old beat up Pinto or a brand new BMW, one car. They don't care the value. Most life insurance policies, if they're term, you can still keep them, but if they're whole life, they usually will have a cash value, and that cash value has a limit. So if it's more than this, we may have to cash it in or try and take a loan against the life insurance to zero out the cash value. Burial spaces and all that is exempt. A lot of times my clients will say, do I have to sell my burial plot to get on Medicaid? No, Medicaid will exempt that. Don't worry about that. You have to report it and let them know you have it, but you don't have to sell it. Life estates, that's a type of property interest. So most people, if they buy a house, they own it outright. They own 100% interest in that house. It's called fee simple, which you may remember from property law. A life estate is lifetime rights to live and enjoy and occupy property. And you can sort of shelter money by purchasing a life estate and property, but there are Medicaid rules about doing that. But if you do have a life estate, after so many months, it is exempt. And so that can be a way to shelter assets. So various ways to plan for long-term care and protect assets for the family or for the community spouse. These are different types of strategies. Personal services contract, which is a caregiving arrangement, where either maybe an adult child is going to look after the parent and get paid so much money a month to look after them. Loans, life estates, certain types of trusts. If you have a disabled child, you can move money into a special needs trust for them, and it's exempt for Medicaid. And savings bonds is a lot. I use those a lot to protect assets for my clients. Medicaid has a 5-year look-back period, which you may have heard of before. So you can't go give away all of your assets and then within the next 5 years apply for Medicaid and expect to be approved. Instead, they will penalize you because they look back and say, did you transfer any assets and not receive fair compensation for those assets or adequate compensation? So in those cases, if I give away $60,000 and then go apply for Medicaid within 5 years, Medicaid, when I'm otherwise eligible, which means if it's just me, I have $2,000 in the bank and no more, Medicaid will say, well, we're not going to pay for however much you gave away divided by 6,000. So if I give away 60, we're not going to pay for 10 months of nursing home care for you. And it doesn't start when you give the money away, it starts when you're otherwise eligible, which means most people don't have any other resources. So it's something to really be aware of. I've had clients that come in my office, because they didn't know what to do. And they're like, well, I just moved all of Mom's money into my account. I'm like, you got to move it back. We're going to have to figure out a different way to shelter it. And maybe you can go do a funeral, prepay for funeral and burial, which is going to be an expense later, so you might as well go ahead and prepay it and shelter assets. It takes at least 45 days to get approved for Medicaid. So you mail in an application, the social services worker will mail back a checklist of what we have to send in, proof of income, proof of assets. That sort of either denied or approved it based on the person's eligibility. Veterans benefits, we talked about this earlier. This is the income people get every month that has nothing to do with if they're aging and if their needs increase. This is, I incurred a disability when I was serving in active duty. And here there's no, you don't have to serve any during a wartime period. Aid and attendance does have that requirement. There are no financial requirements. It's not means tested. So that's that type of income. This is the aid and attendance a lot of people refer to. And again, it's only up to $2,000 per month, $20.54. It will not pay for, it will pay for help pay for assisted living and some independent living. But if that's all you're getting a month, it's not really going to be the main payer source for nursing home care, because nursing home care is more like 7 or 8 a month. So most people either pay out of pocket or spend down and have to get on Medicaid if they're really going to be in a nursing home for several months and years. Okay, I don't know what happened to the bullets, but anyway. So, and then if you are a widow or a widower and your spouse was served in the military, there are benefits available to them. These are monthly amounts. Okay. So Social Security, just briefly, Social Security people can enroll in that when they're 62. Full retirement age right now is 66, or 66 2/3 for the younger people. Most of my clients is 66. If you enroll early at 62, you're going to take a reduction in benefits because they penalize you for enrolling early in Social Security. And they also, if you enroll in Social Security at 62 to start drawing your benefits, there are limits on what you can earn. So you can't go work full time and make your current salary if it's, even if it's $30,000 a year and get your full Social Security amount. So it's better to talk to somebody or do some research, and if you're going to keep working before you start drawing early retirement. If you're going to draw Social Security and work part-time or quit working altogether, then it's okay to draw at 62. But if you're going to keep working full-time, for most people, they should wait to draw it because you're taking a reduction and it just doesn't make sense. You may have an overpayment later. If they pay you too much, it gets very complicated. So Social Security, if you wait to take it after your full retirement age, if you wait until 67 or 68, up to 70, then you can get credits and your Social Security benefit will increase a certain % per year because you're foregoing it, drawing on it. So, but at 70 is when it quits increasing. It's the maximum. If you wait till 75 years Social Security, it's not going to be any higher per month than it would have been at 70. So supplemental security income is an income benefit that's provided by the Social Security Administration. It is not Social Security. This benefit is means tested. So you have to meet certain criteria and you have to meet certain income and asset limits. So for people who, a lot of times who may have been born with something just not right, like they're autistic, or people who became disabled before they were 65, or who are over 65 and maybe never worked, like I had a housekeeper in Pittsburgh who never worked, so she didn't pay into Social Security, and she didn't draw, so she was not eligible for Social Security or Medicare. So she got this. Unfortunately, she got an inheritance, and it made her ineligible, and it kicked her off. And Ms. Clara would not let me put the money in trust to get her back on these benefits. It was very challenging, but this is how much people will get per month. So if you're getting SSI, is what it's commonly referred to as. It's $721 a month for one person. If you and your spouse both need SSI, you're limited to 1082. You can't each get the 721. And you either have to be over 65, under 65, and disabled, or blind. And then the financial, so they limit how much additional income you can receive, be it earned or unearned. And they have different calculations depending on what type of income it is. If you live with somebody for free and you don't contribute anything toward your household expenses, toward your food and shelter, they can reduce it by a third. So a lot of people don't realize that and draw the full amount. And then later Social Security will come back and say, we didn't reduce your benefit, so you owe us X thousands of dollars. And it's, it can get kind of messy. So there are limits, very low resource limits for people. And if you're under 18, Social Security will deem your parents' income and resources to you. So most people under 18, if their parents are working, are not eligible. But once they turn 18, they might be eligible for this. And Medicaid has a 5-year look-back period, so the SSI has a 3-year look-back period. Okay, so those are some of the topics I work in on a day-to-day basis as an elder law attorney. I don't know how much time I have, Joe?
20 time.
Okay. But if you, I don't know how many of you practice in a little bit of this, or if you are interested in practicing elder law, I wouldn't want to do anything else as a lawyer. That's just me. There's a lot of client interaction, and it's a lot of, you see the effects of what you're doing and the people that you're helping, and you get to know your clients really well, and so it's very rewarding in that respect. It's very stressful because your clients, as in most any type of law, your clients are really depending on you, and so you have to really know what you're doing, and so it's I've gotten I think I'm probably going to be a lot of gray hair. I have a lot of gray hair at an early age because it's very stressful, but that's okay. But I don't know how many firms in Richmond have an elder law section. Throughout the state, most elder law practitioners are on their own or just a small firm, and that's all they do. Fortunately, at Thompson McMillan, we have an elder law section. And that's been very useful because I can go upstairs and ask other types of attorneys questions that my clients may have about other areas of law. What questions do y'all have for me, if any, about elder law, estate planning? Yeah.
How do you find that? How do you thread the balance between being blunt with your clients as to what the law actually will say, and yet take into account the sensitivity of the situation? You can't really just say, you can't just bluntly state the facts as they are, because you're dealing with somebody's parent, you're dealing with somebody's spouse, you're dealing with, somebody else's mortality in essence.
So I tend to be very sympathetic to my clients, and I understand where they're coming from when they're like, this isn't fair, this is our situation, and because they always take it very personally. It's like, well, why are, and they'll see somebody else getting these benefits and, feel very just offended that they're not eligible. But I look, a lot of times I'll say, the law is not perfect and the system needs a lot of reform, but this is what it is today. And this is how we can take advantage of the loopholes or the benefits that are available. And, you just kind of, I don't know, you look them in the eye and you just, it's very easy for me to, I don't know, be sympathetic to my clients and understand. But most of them are from, if they've lived any amount of time, they know the rules and various, be it taxes or whatever, they're not fair. So they're not always that surprised. But it can be hard when I have to tell people, no, we can't protect $50,000, you're going to have to pay that. Or I can't get you eligible for this benefit for whatever reason. But I certainly try and, be creative and get my clients as many benefits as I can, and try, make the best of the situation. But it's certainly not easy to. Yeah.
Is there a general sort of like a cost or an estimated investment price that you give clients so that they know how much to
Do you mean as far as what the lawyer will cost, or do you mean as what?
Yeah, like as far as like services. I mean, if you have like a lot of elderly families and you know, even small town kind of families that don't have a lot of money, like you're saying, even like people like I don't have enough in a trust, or whatever. They don't. A lot of times they don't have these kinds of agreements with the wills and you know these power of attorney because a lot of them they don't know that they're affordable to them, and so you would just randomly assign an area of practice that you wanted to recommend someone to install a lawyer, and could you give a ballpark range about how much some of this stuff is going to cost?
So it varies. It depends. But I tend to tell my clients, you know, here's what I normally charge for estate planning documents. If that's too much, or if that's, you know, if they're like, well, I can't do that, it's more important to me that they do them than to worry if my firm, if I get my rate or if my firm, because I do enough work where, you know, for my clients, I do get my rate where I can discount. And luckily, I'm the billing attorney for my cases, so I get to, I'm not relying on another person. So I discount a lot of my clients' work, and I'll tell them, and if I say my initial consult is $225 or $200, people are like, oh, and I'm like, well, pay me over a 4-month period, $50 a month. And then people are like, okay, because that's what I did for a client last week, who now I'm going to get them on Medicaid waiver. But if they hadn't, you know, the 200 was just too scary to them. So most of my clients now will say, you don't owe me anything. We bill at the end of the month, pay it as you're comfortable. Don't put yourself in a bind. And, you know, and I usually will discount a lot, just because, you know, that's just, I'm able to do that. And but I just tell them once we get it all worked out, then we'll talk about, you know, I'll keep you apprised of what the bill is, but it varies. I mean, it depends on if it's a single person and we're just submitting Medicaid paperwork and it's kind of straightforward. That's not going to be very much money. And a lot of times the family can do it, and you just kind of meet with them and kind of tell them what to do. If it is complicated and you're having to shelter assets and really meet with the family a lot, it can be a couple thousand, $2,000 or $3,000, but there's no requirement they pay that. At one time, they can pay it over a year if they need to. So it just the amount really varies. There's no set amount. Even for the powers of attorney, if you know, I've done them for $350, $450 for all 3 documents before. If the person will come to my office and save me a trip from having to go out to them, because a lot of my clients are elderly, so I visit them in their homes, and that's just part of it. You're not going to be behind your desk all day. You're going to the nursing home a lot of times on a Sunday afternoon because a person needs a will and they're not doing well. And so that travel time, you kind of have to bill other time to really meet your billable hour requirement, so as to not charge them to travel to them. But it depends on, most of my clients are well under $3,000 for, if I'm doing Medicaid planning and all of that. If I'm doing estate planning, it's going to be under $7,000, unless it's, unless they're high maintenance, they keep changing it and we go back and forth. Or if there's a trust involved, it might be a little bit over $1,000. But I charge hourly. I don't do a lot of flat fees because I don't feel comfortable personally. I feel doing that because I want to feel like I earned the whole amount. And if I do a flat fee and I know there's money in there I did not earn, I'm not. That's just me. But everybody's great. Are there other questions? Yes.
When are wills, power of attorney, and advance directive effective? So do you just, once it's signed and notarized, is it effective then, or do you have to file a report or go to the hospital?
So that's a good question. So they're effective when you sign it. Okay, there's no other step. Most people do not record a will until it's probated, after the person has passed away, because you don't want, if you record it, it's going to be public record. You don't want people to know what you're planning on giving on and so forth. With a power of attorney, most of those are not recorded. If you use a power of attorney to sign a deed on behalf of someone, you do have to record the original power of attorney then. A medical directive is effective when you sign it. So, but to really be effective and usable, you need to have them on file with the various institutions. The power of attorney needs to be on file with the banking institution. And if my mom gives me her power of attorney, if she signs it and I take it to Wells Fargo, the same, they're not going to let me use it the first time. They have to send it through their legal department. It's going to take a week for they will approve it, and then I can act under power of attorney. The medical directive, your healthcare providers need to have it on file. That way, if something happens to you, you're not scrambling to find, your kids aren't scrambling to find it, and you can go in there and go ahead and talk to the doctors and so forth. So they're effective when they're signed, but to really be useful, you need to have them on file with the various. But a lot of times my clients, most times they'll go ahead and give their powers of attorney document to their children who they name as their agents. Sometimes they'll keep them and just tell their kids where they are. That way they don't have to worry about if they're being used. But most of the time they go ahead and give them to the family. That way you have them. Because if you have them and you put them somewhere, your family doesn't know where they are, it's not useful to anybody. So that's yes.
Just a follow-on question. For the advanced medical directive, is there a particular process for getting into the healthcare provider, or is it just a matter of handing it to your doctor?
It's just a matter of, yes, handing them a copy.
Okay.
And they'll put it in your record. You have a question?
Sort of a related question, not directly related to something you presented, but I've heard in friends in other states that there's a growing number of people who have, I don't know exactly what they're called, but have documents that allow access to their online accounts upon incapacity. Is this something that you've done, or does Virginia even recognize these? Or
So Virginia will recognize them because they're required. Virginia can't not recognize documents that are valid in another state. But most people right now under powers of attorney would have that. It's a matter of knowing the information. If you're power of attorney for somebody, you can access that information, but most people don't know. And the bank, I don't think in Virginia, if I walk in and hand them my power of attorney, they're not going to tell me what my mother's username and password is.
I'm talking less about banking stuff, but more about social media.
For
social media
Like your
email
Facebook
accounts.
yeah, so, I don't know. Virginia doesn't have anything right now that is comparable to that. Yeah, that's very new.
I thought Virginia was. I thought Virginia was looking at giving access to heirs to.
Yeah.
They might be looking at it, but it's very new, and we don't have any. Virginia, nothing's quick, so they might have something at some point. Are there any other questions for Joel? Well, thank y'all for listening to me.